All right, this is Citizenship and Immigration Attorney Parviz Malakouti, and this is our 19th mobility space. Today's topic is renunciation and relinquishment of U.S. citizenship. Is that redundancy? Is that a lawyer using more words than necessary to describe something? Renunciation and relinquishment. Maybe not. And we're going to talk about that. That'll be one of the many topics we talk about today. So just as a reminder for everybody, this is our 19th mobility space. We're doing 50 mobility spaces this year in 2025 on the hottest topics in dual citizenship, freedom of movement, sovereignty, and of course, passports. Our format is informal. Anybody can speak. Anybody is welcome to speak. If you have something to say, just send me a request. I'll approve it right away. I will invite people for comment, but you don't have to wait for comment. If you have something to say, just go right ahead and speak up. So fortunately, I got John Richardson here. He's co-hosting. He graciously agreed to co-host and help us lead some of this discussion today on relinquishment and renunciation of U.S. citizenship. We have inverted fragility, and of course, we have David Blundell, who is very interested in the topic as well. So there's so many different in subfacets of renunciation and relinquishment of U.S. citizenship. John sent me a little bit of kind of an outline of some topics that we could talk about. I'll go over this very briefly, but I can say from the comments, both written and then also in our last mobility space, that one of the big points of curiosity that I think a lot of listeners were interested in is this difference between renunciation and relinquishment of U.S. citizenship. So difference both in how it's done as well as downstream consequences, right? And we've been seeing, at least I've been learning piece by piece over the last, I guess, 2 years or so, just these little minute differences that I see in different, U.S. statutes regarding how renunciants are treated differently than people who relinquish U.S. citizenship, right? So obviously, one of the first ones that comes to mind is the Reed Amendment. That's the ground of inadmissibility in the Immigration and Nationality Act 212 A10E, and this basically makes inadmissible those who renounced U.S. citizenship for the purposes of avoiding taxes. So that's obviously probably at the top of people's minds who are thinking about renouncing U.S. citizenship, at least in my experience, because people, a lot of people who are renounced or who are renunciation curious, they want to be able to come back. They want to be able to visit their family, and obviously, this fear of not being able to return is a concern. So the Reed Act references renunciation. It doesn't reference relinquishment of U.S. citizenship. So that's one. And then we have this topic that we've been kind of talking about more often recently, which is the firearms prohibition, right? And that's referring to 18 USC 922 G, okay? And this has the categories of individuals in the United States who are prohibited from owning, possessing, transporting a firearm. And listed in there is G7, okay? So subsection 7 says, shall be unlawful for a person, and then it says, who having been a citizen of the United States has renounced his citizenship, okay? Again, that doesn't reference relinquishment of citizenship. That references renunciation of citizenship. There's a link, by the way, to one of my articles. I filled up basically the comment section to this space with a lot of resources, some statutes. One of my articles, which references kind of this firearm prohibition for renunciants. So that's one interesting topic. And then, as far as the difference between relinquishment and renunciation, I found in totally unrelated research, this was new to me, maybe this isn't new to John or others in the space, but I found actually in unrelated research that for T visas, so a T visa is a U.S. visa for victims of human trafficking in the United States, and T visas, just to give some context, have kind of built-in waivers of inadmissibility for a wide variety of grounds of inadmissibility. Okay, so material misrepresentations are waived if a person gets a T visa. Previous unlawful entries, previous unlawful presence, et cetera. And I found actually, to my surprise, in the Immigration and Nationality Act, that one of the only grounds of inadmissibility that's not waivable for a person who's granted a T visa is INA 212A10E, okay? the Reed Act ground of inadmissibility. Okay, and I have a link to this tweet that I made about 3 months ago. I also linked to this mobility space. So what this means basically, and this is super niche, right? I doubt that very many people would ever find themselves in this situation. Maybe nobody has to date, but I think it's just a really interesting, bit that might show some, be illustrative of how renunciates are thought about when this section was made. This means that if you are a U.S. citizen, okay, and you renounce U.S. citizenship, not necessarily relinquish, but renounce U.S. citizenship, okay, and then you are later trafficked, okay, human trafficking, such that you may qualify for a U.S. T visa, okay, all of these other grounds of inadmissibility that you might have against you could be waivable, which means basically you could still be able to get the T visa, eventually get the status, eventually get legal permanent residence. But if you are a renunciant and you were found to be inadmissible under the Reed Act, right, meaning having renounced U.S. citizenship for the purposes of avoiding taxation, then you don't qualify for this waiver, right? And so that's really interesting. And I'd be curious if ever there's been a case like that where a renunciant, let alone a renunciant who was considered inadmissible under the Reed Act, but just any renunciant, whether they've ever applied for a T visa after the fact. So I just thought that's one very interesting kind of difference, I guess, distinction, very much downstream, very niche, between renunciants and relinquishers. So anyway, this is John's suggestion of some topics that we could talk about, and we don't have to talk about all of them. We don't have to talk about these in order, but I'm just going to throw these out there, and then I'm going to open up the floor for discussion with a question to John. Okay, so. The first thing is all U.S. citizens. This is John's writing. All U.S. citizens have dual U.S. citizenship. One is tax citizenship, and second is citizenship for immigration purposes. Okay, and this is a great point, right? Because people talk about, oh, are you a U.S. citizen? Are you a U.S. citizen? And as we've discussed before on previous spaces, both mine and John's, that question is incomplete if you don't have at the end of it, for what purpose? Are you a U.S. citizen for what purpose, right? And because there's a tax code and there's an Immigration and Nationality Act, right, and they don't exactly mirror one another in terms of who's considered a citizen, we end up with these kind of unusual situations where a person could be a citizen possibly for immigration purposes, not for tax purposes, and vice versa. So that's a very important issue, interesting issue. Second one is renounce versus relinquish. What is the difference? Okay. Why relinquishments may be less damaging in the future. No Reed Amendment, no firearms prohibition. Again, this is John's writing, and that speaks to what I just mentioned a few minutes ago, regarding the Reed Amendment. Next, relinquishing citizen for immigration purposes versus relinquishing citizenship for tax purposes. The tax citizen was created on June 3rd, 2004. And of course, I'll invite John to explain that and what he means by that. Next, renunciation versus relinquishment. What is the date of expatriation for tax purposes, for immigration purposes? How are they different? Okay. And then I'm going to finish up here with I won't read the rest of what he wrote here, but here's a final interesting one. Okay. Citizen of the United States. Okay, so the United States person, for purpose of this section, the term United States person means a citizen of the United States, not tied to the definition of the IRC. Okay, and that gets into this interesting topic of whether for FBAR purposes, right, a person might be able to make an argument that they are a citizen or not a citizen based off of either the tax code definition or the Immigration and Nationality Act definition. And this was discussed by Virginia Jaker, I believe that's how her name is pronounced, and John in one of John's most recent podcasts. So that's a really interesting topic as well. Okay, let's kick this off with a general question to my co-host here, John Richardson. Okay, I think let's go bottom line up front. I think most people are interested in this, in jumping into the difference between relinquishment and renunciation of U.S. citizenship. Okay, so general question, John. Okay, if a person can reliably relinquish U.S. citizenship. Okay, what I mean by that is reliably is make the relinquishment, right, and not have to go through litigation later with U.S. Department of State about whether a relinquishment occurred and what the date of that relinquishment was. If the person can do that, generally speaking, is it more advantageous to relinquish U.S. citizenship than to renounce?
Right. I think absolutely, positively, yes, if you can do it. But and if I don't get to that, remind me, because this is an extremely important point. Okay, sort of to preface this, everybody's talking about renounce versus relinquish, and this is a very, very good example of how the commentators create the categories rather than the law. What's interesting is that if you look at, this is all governed by Section 349A of the INA, but that section speaks only of relinquishment, only of relinquishment. Actually, there is only relinquishment, and renunciation is simply one of the 7 forms of relinquishment. Okay, so let me say that again. There is, from a legal point of view, there is only relinquishment. Renunciation is one kind or one form of relinquishment. What distinguishes renunciation from other forms of relinquishment is that renunciation is where you go and stand before a representative of the U.S. government and voluntarily and intentionally take an oath of renunciation, which is the relinquishment of citizenship, right? In other words, that's how you do it in real time with the acquiescence, if you will, of the government. All the other forms of relinquishment are things that are done outside the consulate. They're in fact, I think, always done before you stand before somebody in the consulate asking for a certificate of loss of nationality based on that, or in some cases, mostly the old days, when they would issue you a certificate of loss of nationality instead of a passport based on something that you've done. So I think it's extremely important conceptually to understand that renunciation is simply one form of relinquishment. Now, all forms of relinquishment, since 1986 statutorily under the Immigration Nationality Act, and I think from a Supreme Court, from a judicial perspective, in the 1967 Aforium case, all forms of relinquishment require that the relinquishment have been done voluntarily and with the intention to relinquish U.S. citizenship. Now, it's pretty clear that if you go in and renounce, that you're doing it voluntarily, or at least mostly clear, and that you're doing it with the intention of relinquishing U.S. citizenship, mostly clear. I mean, there are procedures in the Foreign Affairs Manual that they're required to follow to ensure those kinds of things. However, with a relinquishment, it can be extremely, minimally, it's far more difficult, all right, to establish the relinquishment. Now, the burden of proof on the voluntariness relies on the person seeking the certificate of loss of nationality. The burden of proof on intention actually lies with the government, right? So we have 2 different things going on. Now, let's take what I would say is the most common example of somebody going into a consulate and not to renounce, but to say, hey, I'm here to tell you that I've relinquished U.S. citizenship under Section 349A1 of the Immigration Nationality Act, specifically by naturalizing as a citizen of, why don't we say, Canada, with the intention of relinquishing U.S. citizenship. That's what's happened. That's the deal. Those are the circumstances. Under the law, I'm no longer a U.S. citizen, and the only reason I'm here is because I want you to issue that certificate of loss of nationality so I can go on and live my life as a free person. Okay? Now, lest I forget to say this, all right, and there's a post about this on my site, and it was actually reproduced at the Isaac Brock Society as well. This is so important. Over the last few years, it has become somewhere between difficult and impossible to get a certificate of loss of nationality issued based on a non-renunciatory relinquishment. Now, I don't know if this is because I've heard rumors that, during the COVID period, there were some changes in the structure of the a legal department of the State Department who deals with this, whether it's a reinterpretation of what the standard of proof should be in voluntariness or intention, whatever. But I can tell you that I have had 3, 4, maybe 5, somewhere in that range, not a lot, of people who sought certificates in the last, say, 3 years, who sought certificates of loss of nationality based on non-renunciatory relinquishing acts, who have received no response from the State Department, no response at all. And it is so bad that 2 years ago, I had somebody go into a consulate with, I think, an absolutely airtight case, at least, based on all the years that I've done this. And, for many years, I've, if this is done properly, okay, you can get these things, okay. I had no problem getting these things. It's been 2.5 years since the woman was at the consulate. It was an incredibly strong case. And they responded to her once by having a follow-up meeting, talking about the intention and voluntariness. Nothing since. And she's just thrown in the towel and said, nah, I think I'll just renounce because I need the certificate of loss of nationality. So that's the theory. That's the reality. I'll pause there.
Yeah, I'm glad you brought up the point in the beginning about the terms. We have to define our terms, right, when we speak to one another to make sure we're on the same page. John, do you think a good kind of rule of communication about this would be to refer to renunciations and non-renunciation relinquishments? Do you think, how should we distinguish between the two when we're talking to make sure that we're not giving the impression that they're like two totally different categories rather than one nested within the other?
I think the train left the station a long time ago. I think in the legal community, the tax community, I think that they've got it in their heads that these are different things. And I would make no effort to resist that. In terms of conversation, I think you're more likely to confuse because you have to give an explanation for it. But I'll tell you why this matters, okay, and why it matters hugely, okay? And I want to make this, if I'm not making this point clearly, press me on it until it's crystal clear. So, and I'm sure you would agree with this. I think it's always a great idea to start with the law, when you analyze this stuff. And what Section 349A says, all right, is that, for example, somebody who becomes naturalized citizen of another country, voluntarily with intention, relinquishes U.S. citizenship. Now, that relinquishment, in my view, and I am very committed to this view, takes place at the time of becoming the citizen of the other country, as long as it's done voluntarily and with the intention. It is not dependent on receiving a certificate of loss of nationality, right? The certificate of loss of nationality is simply the confirmation. Now, what that means is that the loss of citizenship took place on the date of naturalizing a citizen of another country. Now, let's think about what that might mean, for a number of people. Now, prior to June 3rd, 2004, we can get into this if you want, the definition of U.S. citizen for tax purposes followed the definition for immigration purposes, right? So if you have somebody who can meet the test of relinquishment, okay, prior to June 3rd, 2004, and I'd be happy to send you all out a fairly detailed post I read on this if you just send me an email. I wrote on this 10 years ago, I think, at this point, where I make the point that person is no longer a U.S. citizen, okay, at the point that the tax citizen is created, all right? So I have always taken the position, and this has never really been litigated, I think correctly, that those who can persuasively argue a relinquishing act prior to June 3rd, 2004 are out of this mess. Okay, they should be entitled to a certificate of loss of nationality if the State Department ever begins addressing those issues. Again, I don't know. I really don't know what they're doing there. Okay, but they're not responding to them. They're simply not responding. Okay, so you see where I'm going on this? If, however, the Relinquishing Act was after June 3rd, 2004, the creation of the tax citizen, then the tax code has certain things to say about when the person lost citizenship for tax purposes, right? And, so different rules between 2004 and 2008 were, I think, further enough along in the modern era, which is June 16th, 2008, so that a CLN is actually required after June 16th, 2008 to have lost citizenship for tax purposes. Okay, is this making sense to you? Now,
Yeah.
this is why, and the old days, I don't know, meaning 3 years ago or something. I mean, I had like a 10, 12-year run of being able to help people get these, these back, which we call informally backdated relinquishments. Then it just seemed to dry up. But there were two reasons people wanted those. The first reason was, well, actually, in no particular order. One reason was the whole tax issue, right? If they can argue they're not citizens for tax reasons, that's really good. Now, I want to pause here for a minute. There is a subset, whatever, of lawyers who take the position that the 877A rules enacted that came into effect on June 16, 2008, they read them retroactively. And they say it doesn't matter. I think that's wrong to read that stuff retroactively. And in addition to that, I see no reason, to read it retroactively, right? But, I don't know, who's on this call necessarily, whether you're just interested in this, your lawyers, what have you. But I would be very, very wary of anybody who takes the position that the modern day exit tax rules are retroactive. Okay. But anyway, so that's the first reason they'd want the backdated relinquishment, to try to avoid the tax issue. And so far, I'm not aware of anybody with a backdated relinquishment prior to June 3rd, 2004, who has had a problem with the taxes, okay? Now, the second reason is perhaps less obvious, but even more interesting. And that is that, as many of you know, well, all of you know, I think, that U.S. citizenship, provided that certain presence requirements are met, allows you to transmit citizenship to a child born outside the United States, right? And so somebody comes in and says, well, from what date, when did I lose my citizenship, right? There are people, who really fought this, right, who have argued very hard for backdated relinquishments predating the date their child was born because they didn't want any possibility of their child being accused of being a U.S. citizen because of all of these problems. But so, what we have is the interaction here between tax citizenship and citizenship for nationality purposes. And then we have citizenship laws under varying dates. With these things have evolved and shifting, tax state. So, this stuff is a hell of a lot more complicated than the average American abroad imagines.
Yeah, absolutely. John, you spoke about voluntariness and intention. I'd like to read subsection A of INA 349 and just ask you a question. So this
Sure.
reads a person who is a national of the United States, whether by birth or naturalization, shall lose his nationality by voluntarily performing any of the following acts with the intention of relinquishing United States nationality. And then subsections 1 through 7 describe different acts. So naturalizing in a foreign country, serving or performing the duties of office under a foreign government, renouncing, of course, right? So there's 7 acts listed under there. Voluntariness and intention. You've spoken about them. What's the difference between these 2 requirements?
Well, at the risk of oversimplification, voluntariness means nobody was forcing you to do it. And intention means that when you did it, you were doing it specifically. It's like in a criminal case, right? With a specific intent to achieve the result of relinquishing U.S. citizenship, right? So, we could take a situation where, now, the State Department, to their credit, but I don't want to create the impression that I think they're the enemy. I actually don't think they're the enemy. And I think that they should be seen as cooperative partners, in the whole exercise. But they're very, very aggressive on the issue of voluntariness and intention. So the way they test voluntariness is usually is anybody pressuring you to do this, right? So you could have, for example, a situation where, you could have an American citizen married to a non-citizen, and the non-citizen, can't deal with, the obligations of having a U.S. citizen spouse. I would say, look, either I'm not going to pay these tax compliance fees anymore. Okay, I can't afford thousands of dollars a year. Basically, it's like this. Okay, you're going to have to renounce U.S. citizenship, or you're going to have to find some other way to pay for this. Okay, or I'm sorry, I can't live listening to this anymore. Okay, I'm out of the marriage unless you renounce citizenship. Now, that type of stuff would, I think, not meet the test of voluntariness, right? Because of, duress, coercion, this sort of stuff, right? But the point is that somebody could actually be in a position of voluntarily renouncing, but not intending to renounce U.S. citizenship, right? They could be intending to achieve another kind of result, right? Saving their marriage, or I've actually got one going on right now that's interesting. That this person's life was threatened if she did not leave the United States and renounce citizenship, and she succumbed to the threat, etc. And now the issue there is, what was she really intending to do, right? But, those are the differences, right? I mean, just see it as, you studied criminal law at some point, right? Just see it as having actually committed the act, but you have to do it with a certain intention, right? Make sense?
Yeah. Sorry. Absolutely. And the bottom of INA 349 speaks to some of the burdens of proof. Subsection says, whenever the loss of United States nationality is put in issue and the action or proceeding commenced on or after September 26, 1961, under or by virtue of the provisions of this chapter, the burden shall be upon the person or party claiming that such loss occurred to establish such claim by a preponderance of the evidence. Okay, so generally speaking, it sounds like the burden is on the person claiming that the loss of nationality occurred. And people, maybe not this crowd, because a lot of people here understand the potential benefits of relinquishing U.S. citizenship. But I would venture to guess, John, that the average American thinks, oh, for sure, it wouldn't be a person litigating with the U.S. government and the person trying to claim that they relinquished, and the U.S. government trying to prove they did not relinquish. But in fact, that is the case sometimes. And as you saw, John, there was a comment by Brad Banias, a U.S. immigration lawyer who was a former Department of Justice lawyer, and he said here, and I've linked to his tweet here. He says that he litigated 2 cases with the DOJ. And he said, weirdly, both of the cases I litigated, one I represented State Department and the other I represented a Swiss national who was born in the US. The individuals wanted to lose their US citizenship, and the State Department made it as hard as possible for them to do so. But both individuals won and got certificates of loss of nationality. Now, it wasn't in that tweet thread, it wasn't crystal clear that he was talking about a case where there was where these people were trying to claim relinquishment over renunciation, but I presumed that was the case. I don't know about you, John. Right?
Yeah, I think that is absolutely the case. Yeah. So this is a really interesting thing. Now, my interest background in this goes back, a lot of years. And one of the things that comment thread, I remember seeing that, he mentioned the Board of Appellate Review, which doesn't exist anymore. But during the, starting from around 1980, see what was happening, in the old days was this, that, there were a few people who were renouncing U.S. citizenship or relinquishing, and the ones who were, they were not, everyday sort of people, right? Trying to make a living. Okay. And, they had, some specific grudge, against the government or something like this. But what would happen would be this. Let me give you a really, really, down to earth, simple example. And I saw a lot of these. So, probably people on the call are, way too young to have seen this in real time, but maybe have a memory of the Vietnam War and all kinds of Americans moving to Canada, right? In the, in the late 60s and the early 70s. Now, what happened was, now, first of all, this is maybe after the Euphorium decision, but the State Department is still reading the law as if you, naturalize as a Canadian citizen, you're going to lose your U.S. citizenship, right? So what happened was that, there were a lot of American citizens who moved to Canada, because they were draft dodgers. I know that's a pejorative term. I just can't think of a better word for the moment, but you know what I mean. They didn't want to comply. They were sympathizers with Muhammad Ali, okay? They didn't want to comply, with the draft laws, and Canada kind of welcomed them, and they became Canadian citizens. And the other group there was a huge expansion of the Canadian university system, and all kinds of American academics, PhDs moved to Canada. But the point is, these people became Canadian citizens. They would then go to renew there was a citizenship requirement to practice law in Canada at that time, right, or in some of the provinces. Where they became a Canadian citizen, either to live there, to practice law, or to become a teacher. And there are all kinds of, reasons why people might have become Canadian citizens. They then go to renew their U.S. passport. And the passport application process, I'm certain still does, ask about relinquishing acts. So they'd say, well, yeah, I became a Canadian citizen. And and the passport the U.S. consulate on University Avenue in Toronto might say, well, today's your lucky day, you've expatriated yourself, you've lost your U.S. citizenship. And, a lot of people were not fine with that at all. And so there was an appeal process where you go to this place called the Board of Appellate Review, which was a division of the State Department. And this is a group of people. The chairman was a man named Alan James. And, they basically would make the decision, they develop the facts. And now, did the State Department carry its burden of proof on the issue of intention? Specifically, did these people become Canadian citizens with the intention of, relinquishing U.S. citizenship? And they might or they might not have, okay? But the point is that those who assert that they had not intended to relinquish U.S. citizenship were actually able to get it back during that era. I mean, I've seen hundreds, of decisions where the Board of Appellate Review overruled the State Department and just said, no, the State Department didn't carry its burden of intent. Now, during that period, nobody could have foreseen, the evolution of the tax code, the citizenship laws, the modern day Democratic Party, which is largely responsible for these rules, et cetera, et cetera. So now, okay, we're in a situation where people don't want U.S. citizenship, right? So what's happened is that, yes, the State Department still bears the burden of proof on intention, but you've got these people now arguing they did commit the Relinquishing Act, right? So up until, I would say probably 2009, 2010, you've got people saying that they didn't commit a Relinquishing Act because they didn't intend to relinquish U.S. citizenship. Now the position's been reversed. They're saying, of course, I committed a Relinquishing Act. Of course, I wanted to voluntarily relinquish U.S. citizenship. So the world has changed, and the arguments and essentially the rules have changed, interestingly. So, I mean, the man in the thread didn't say a lot about it, but what I would envision that would mean would be that you've got somebody who, yes, maybe a Swiss citizen, what have you, or somebody who became a Swiss citizen and was arguing that that was a relinquishing act. And I would expect the State Department doesn't want to issue the CLN because, in the same way that for criminal liability, the actus reus and mens rea must exist at the same time, for relinquishment, the voluntariness and the intention to relinquish must exist at the same time, right? So what they're saying is, well, you might have naturalized a citizen in another country, but, the element of intention didn't exist at the time that you did it or something. I mean, I can see a lot of that. And that, by the way, is how, as far as I can see, they are trying to develop relinquishment cases now. Okay. So if here's a bit of free advice for anybody listening to this. I was thinking, how would you as a lawyer develop a relinquishment case today? And I think the answer would be, I think you've got to show, you have to show that you intended to relinquish U.S. citizenship by the act. And what you would do, it'd be very, very helpful to have a letter from a lawyer saying that here's what the law is. And, in order to relinquish, you have to be intending to relinquish U.S. citizenship. And, to help you, you can use this letter, but I'll also help you draft an affidavit on the date of the Relinquishing Act to support the claim that you did intend to relinquish U.S. citizenship. Now, on the issue of affidavits, why do they matter? Because in the old days, people would swear an affidavit on the date they naturalized a citizen of another country, specifically swearing that they did not intend to relinquish U.S. citizenship, right? But, affidavits matter, evidence matters. Most of the world has nothing to do with truth. It has to do with proof. Okay? And, one difference between renunciation and the other forms of relinquishment is that with renunciation, you've got real life proof. Right? The problem with these other things that took place outside the consulate is you have to kind of reconstruct what was going on.
John, so you just went right into the next topic I wanted to ask you about, which is proving intent. My question was going to be: do you hold a press conference when you're doing the Relinquishing Act and say, hey, this is my announcement to the world? And then, naturally, there's some curiosity about developing proof of intent that is not made, let's call it, quote unquote, public yet, right? Some people are curious. I think somebody even made a comment or a question about making an affidavit, developing proof of intent, okay, that's not necessarily made public or handed over to the U.S. government. That's just locked away in your drawer, okay, for you to be.
I don't think there's any one answer to that question. No, I would not do a public press conference, period. Okay. I assume you're not serious.
No.
I think that there are, certain aspects of life you need to keep pretty close to your chest, and this is one of them. What I would do, I think, is the following. Okay. The first thing I would do is I would get legal advice, and I would get legal advice from somebody who actually understands this stuff, like say you, okay? You know, and what you then want is you want to develop a conversation between the legal advisor and the person, okay? So that they understand the law. All right, that's the first thing. I mean, understanding the law is not the key specifically, okay? It's voluntary relinquishment plus intention, irrespective of your knowledge of the law, okay? However, I think it should include knowledge of the law, right? Because part of the issue here is they say, well, how did you know you relinquished U.S. citizenship, right? By doing this. So I would do that. Then what I would do is I would get an affidavit drafted, okay, with the help of a lawyer, making it very, very clear what the purpose of the affidavit is, that you're intending to relinquish by becoming a Canadian citizen, and the purpose of the affidavit is to provide contemporaneous a proof, okay, of what was going on in my mind at that time. So that's what I would do. And I think I might bolster that with, maybe some affidavits from a few other people sworn at the same time, friends, anybody, okay, just people who will say, yes, I know that that's what this person claimed they were intending, right?
Yeah, and I want to play devil's advocate a little bit about this proof. Let's call it latent proof of intent. Okay, so proof that's generated concurrently at the time of the alleged relinquishing act, but that you just keep private, right? So I'm just gonna play devil's advocate, John. If I'm representing the U.S. State Department and I have a case like this before me, and I want to say the person did not relinquish, the person wants to say yes, they did relinquish, and they put forth all of this proof that was generated in private and kept in private, okay, but only brought forth when the person wanted to actually prove the relinquishment, okay, to their benefit somehow. And people act generally in their own benefit, right? People do things and initiate processes typically when they perceive it's going to be to their benefit. If I'm the lawyer on the other side, I mean, do you think, and again, I know this is maybe going off a little bit in the weeds, but do you think that there's an argument that from the other side that if you've not somehow let that proof of intent be known, okay, in a reasonable time after you claim the intent was made, that effectively what you've done is created a free upside to relinquishment for yourself, as well as a free upside claiming you're still a U.S. citizen because you're the only one who holds this element, proof of this element, and you're just keeping it, to yourself until or when you perceive that it's to your benefit to do so. Do you think in mass? I guess this is what I'm saying. Do you think in mass, if there's thousands of people that do this, that develop proof of intent, affidavits from the lawyer, affidavits from themselves, affidavits from people who know them, and just hold them close to the chest until they perceive the exact moment it makes sense for them to prove that they've relinquished citizen? Do you think that would fly if 3,000 people were doing that, 4,000 people were doing that?
Well, first of all, to create affidavits is not proof, it's evidence of intention, right? It's evidence. It's not proof of anything. It's evidence of intention. So the first thing I would say is that, so the question is, does the length of time, okay, et cetera, depreciate the value of that as evidence? And I think, yes, it does. Okay, that would be my guess. I mean, I would advise somebody, to move as quickly as reasonably possible on this sort of issue. Now, I'll tell you a real live case where my understanding is this is a bit of an issue, right? And this is it's in the public, okay, but there's a former Navy pilot in Australia, okay, who is formerly a U.S. citizen, who has gotten himself ensnared in all kinds of legal problems, and the U.S. is trying to extradite him to the U.S., etc. You can easily find this if you want. But one of the things, and this is just public record stuff, okay? I mean, I don't know anything that's on the public record, obviously, right? But it was interesting. I mean, the date that he ceased to be a U.S. citizenship has some relevance to this case. And what happened in his case was, I think it was 2012, he naturalized as an Australian citizen. In 2000, I think it was 16 or 15 or something, he finally goes to a U.S. consulate and says, I want my certificate of loss of nationality, okay? Now, I think since that time, okay, I think it's getting harder. I think it's getting harder to get these. There's no question it's getting harder to get these things, okay? But he was successful, okay? He was successful, and he was successful simply on the basis that, you know, he said, well, you know, yes, I naturalized as an Australian to relinquish my U.S. citizenship. And since that time, right, now this is obviously, I think we need to add this is critical, is that from the time of the Relinquishing Act, you can do nothing that would hold yourself out as a U.S. citizen, okay? You know, which would include the obvious: applying for a U.S. passport, applying for a Nexus card. Be careful, okay? By the way, if you're renouncing citizenship, make sure you never use that Nexus card again, okay? Because that's holding yourself out as a U.S. citizen, etc. So, you know, interestingly, this is a well-known case. It wasn't clear at that moment that it was going to explode the way it has, but they never argued that. You know, it was 3 years. I mean, I don't think I could do this today. I don't think, but I don't know. But I have in the past helped people get backdated relinquishments going back 15, 20 years.
Yeah, that's the Dan Duggan case. That's a fascinating case. I put a link
That's exactly who it is, Dan Duggan. Yeah.
So this is a military pilot who moved to Australia, naturalized there in 2012, and he's basically being sought by the U.S. government for extradition for having illegally trained Chinese military pilots, right? What does this have to do with citizenship? Well, because the United States law at the time that he's alleged to have trained these Chinese military pilots prohibited U.S. citizens from doing this. And again, this is another example of an extraterritorial obligation imposed on a citizen. Okay, and one of the big reasons that we always talk about, and John talks about, of course, understanding when you're naturalizing somewhere or claiming citizenship, you know, that you're going to be obligations are going to be imposed on you legally that apply to you outside of the country, extraterritorially imposed. That's important. It's really important for you to know what those are. But anyway, the upshot is that if he was not a U.S. citizen at the time that he did this, that he trained these Chinese military pilots, well, effectively, that should collapse the case of the United States government against him. Okay, if he was a U.S. citizen during that time, right, then obviously they can claim, you know, jurisdiction over him fairly easily as a U.S. government. As a U.S. citizen. Okay, so he's claiming. I'm just looking at. I don't know if this is 100% accurate, but I'm looking at this article from abc.net.au. Okay.
Yeah, I know the article.
Right, claims that he not renounced, that he naturalized in Australia in 2012, relinquished United States citizenship at that time, and it didn't become illegal for Australians to train Chinese pilots until 2018. Okay, so I guess the hot area is 2012 to 2018. Okay, was he a U.S. citizen or not during that time? Right, and this guy's life literally depends on it. It's not just a matter of finances.
It does. And I'm surprised that this hasn't been developed because I think it's a very important issue. What I do believe, and I think the article you're referring to, I believe there's an interview clip with him where he himself makes this point. Okay. This is really interesting. Well, to me, it's interesting, but it is broad application. So remember that I said that to lose citizenship for tax purposes, you need the certificate of loss of nationality after 2008. So apparently the U.S. government is trying to using the tax definition of citizenship, claiming that he was actually a U.S. citizen until the CLN was issued in whatever that was, 2016. And this is extremely interesting. And this is why I think Americans abroad should be very, very interested in this case, right? Because what the U.S. government is saying is that you don't lose citizenship for nationality purposes until a CLN is issued. And I think that that is absolutely flat out wrong. That is not what the statute says. I mean, you've got the statute open in front of you. There's nowhere in that statute that says that the loss of citizenship for nationality purposes is conditional on a CLN being issued. That's a tax concept, not nationality, right? So, I mean, I read the indictment a while ago in the Duggan case, and what struck me about it was, you seem to be a little better versed in the background facts than I am. But what struck me about it was that it was very, very clear that some of the things he was accused of doing took place at a time that he had definitely lost citizenship for nationality purposes, right?
Yeah, exactly. That's certainly what I mean. That's certainly what the timeline would suggest. Yeah, so this, you touched on this topic, and I feel like John, we talk about this. We've talked about this probably at least 3-4 times in different lives, and maybe this is a boring concept for most people. I don't know. It's tough for me to judge because I like this stuff. But
It is. It is. I'll help you with that. It
okay,
is a
okay,
boring. Yeah.
okay.
Okay.
But the concept is this thing that you just said, which is the proof of something, or you said something to the extent that of we live in a world of proof, not actually what's the reality or what actually happened.
Yeah.
Uh,
This is not a search for truth. Well, ultimately it is, but really it's a search for proof.
exactly, right. And we've spoken about this previously in the context of who is a U.S. citizen, proving the fact of being a U.S. citizen, whether it be in the U.S., born to an undocumented person, and possibly caught up, by Trump's attack on birthright citizenship, or if it's a U.S. citizen born abroad, right, to a parent, right, that just doesn't ever, register their birth, right. It's
Yeah.
it
Now, by the way, on that, okay, the U.S. citizen born abroad does not have a 14th Amendment, the 14th Amendment protections of citizenship. Right, because remember the 14th Amendment says born or naturalized in the U.S. They may have a statutory protection, but those people could be stripped of their citizenship, no problem.
Yeah, that's right. Exactly. So that citizenship right is made by statute. That's exactly
Yeah.
right. Yep. So the proof right is where the battleground is, right? Not necessarily where what is actually the truth. It's like the old adage. It's not what I'm gonna mess this up. It's not what you know, it's what you can prove. I butchered it, but that's obviously the upshot here. John, what about the Ver case? By the way, it's just been you and me speaking, John. Anybody else who wants to talk? Oh, we got Alex here. Alex will talk for sure. Anybody who wants to talk, ask a question, bring their own comments in. Jump right in. Okay, just jump right in. Okay. Um,
Yeah, I was wondering if you can clarify that the born abroad citizen can be stripped. Is that before they get their citizenship or their CRBA, or even after they get their CRBA, they can still be stripped as well?
Um, I don't know. I mean, I can. Yeah, who do you want to answer that?
So I'll start it off. So Alex, first of all, the right to U.S. citizenship of people born abroad to U.S. citizens is a statutory right to begin with. Okay, it's not quote unquote backed by the Constitution. It doesn't have its root, in the Constitution or beforehand. So that's the actual nature of the right itself. Okay. As far as being stripped of citizenship, I'm not deep in the case law really on this, but no, I believe also that they're not protected by even after the fact, after the CRBA. I believe that right, and correct me if I'm wrong, John, is not protected by the 14th Amendment either.
No, it's not. It's not protected at all. Um, I mean, I think that probably the answer would be best by just saying, look, cases like a Forium that say, you can only lose your citizenship if you voluntarily intend to relinquishment. That's because of the 14th Amendment. And the 14th Amendment applies only to people who are born in the United States or naturalized. The idea of somebody becoming a U.S. citizen if they're born abroad, that's from a statute. Now they can't they can't just take their citizenship, without changing the statute, right? I mean, what I meant was that people born abroad, okay, don't have these constitutional protections. Okay, even in the current environment, I don't think that the United States would simply, de-citizenshipize those people. What I am saying is that it'd be very, very easy to amend the Immigration and Nationality Act so that those people had no right to U.S. citizenship.
Yeah, exactly. I mean, a right that requires a two-thirds majority vote in the House as well as the Senate in order to amend the Constitution is going to be, of course, more robust, generally speaking, than a right that can just be changed, just by statute, right? Just by majority vote in Congress. One last thing, I want to go back real quickly to voluntariness and intention. So the Afroim case, John, as you know, and just for others, there's a lot of discussion in that case, both in the opinion as well as in the oral argument, about how voluntariness of the Relinquishing Act and intent to relinquish the U.S. citizenship interact with one another, right? And the lawyers for Rusk, okay, Secretary of State, so the Department of State side, okay, tried to make the argument that if you do if you voluntarily do an expatriating act, okay, and you intend to do the act, then the intention requirement, right? Then you've had intention, okay, to relinquish U.S. citizenship, right? And obviously, the Afroim case was arguing, to the contrary, that in addition to voluntarily performing the expatriating act, the person has to specifically and independently intend to be rid of the U.S. citizenship, right? And I think that's an important point, right? Because that's whereas before, kind of these two concepts were wrapped up into one thing, okay, the actual voluntariness of the act. It seems like they were much more separated out, okay, and parsed out as two separate, much more robustly, defined as two separate requirements, right? Now, in Afroim's case, okay, this is a guy who naturalized the United States. He wanted to keep his U.S. citizen. He wanted to not be stripped of citizenship for having voted in a foreign country, in Israel in this case. But funny enough, John, for people nowadays, okay, your clients trying to relinquish, okay, the building up of that intention requirement, okay, as a separate, requirement, actually might be working more to the detriment of people nowadays, right? Who are trying to basically prove that they lost the citizenship, right? So I just wanted to just maybe double click on that concept a little bit and get your thoughts. I mean, Afroim, he made U.S. citizenship more robust for the purposes of not losing it, let's call it, without wanting to lose it, right? But for all these people trying to relinquish citizenship now, like now it's pretty clear that you have to independently prove intent, and intent is not assumed. Intent to lose U.S. citizenship is not assumed by your voluntariness in performing that act, whether it be naturalizing elsewhere.
Well, that's true. That is true for certain relinquishing acts and not for others. Okay, to be clear. The State Department has, in 1991, or maybe it was 1990, adopted an administrative standard for burden of proof, or for proof, to the effect that simply naturalizing or voting in another country, that the State Department would presume that you did not intend to relinquish U.S. citizenship. Now, for some of the other stuff there, okay, like, armed forces, this sort of stuff, that is not the case. Or for certain types of government employment that involve policy making, again, there is no presumption of intending to retain citizenship, right? So, all of these things need to be developed on their facts, right? So, for example, although years ago, I was successful in helping people get backdated relinquishments for relatively low-level government employment, foreign government employment, that is. I don't think you can get that anymore, okay? I'm fairly confident that, that somebody who was involved in a foreign government and a policy level thing, or law enforcement. I mean, I once helped a senior, very, very senior police officer in Canada get a backdated relinquishment. But again, this is the type of thing where I think it's dangerous to overgeneralize. Because you see, there are certain types of relinquishing acts that are clearly more indicative of intent to relinquish. For example, dual loyalties, for example, be a problem. And we talked in the last space about, the issue of, for example, Andrew Scheer, when he was head of the Conservative Party of Canada, what if he become prime minister? I'm reasonably confident that he could have taken the position that by doing so, he intended to, relinquish his U.S. citizenship, because that's a policy level, area, right?
Yeah, absolutely. No, thank you for sharing that experience of helping people get backdated relinquishments who just had lower, you said low level foreign government experience.
Oh, that was so long ago. That was so long ago. Look, my current stance on this is to, to just renounce. In fact, I have one of my Twitter handles is just renounce, in fact, right? But, that's my current stance. And there's another reason to just renounce, and I'll tell you what it is. That, look, let's not kid ourselves, okay? This is a problem for the IRS. It's a problem for the U.S. government, not a major problem, but a problem. And the IRS created this thing called the relief procedures for former citizens. It's a way for people who renounced, okay, basically to do sort of a fake tax return filing. And so everybody, wink, wink, claims they're all, it's not quite as bad as that, but it's a lot less onerous than normal tax filing, okay? But in order to do that, you have to have a relinquishing act after March 18th, 2010. So my point is that it makes good sense for an awful lot of people to simply take the position they're going to go and renounce after March 18th, 2010 to avoid covered expatriate status, right? Under the tax laws. Now, why would they do that? Because remember that the problem of covered expatriate status is twofold. It's one, the exit tax, which may or may not be an issue, but where it's really a problem is, to make gifts to U.S. citizen, gifts and bequests to U.S. citizen children down the road, right? So people want to avoid covered expatriate status, and for that reason, there are people who I think should just be saying, whatever happened in the past, we don't really care. Just go and renounce. Do the relief procedures for former citizens. You're no longer a U.S. citizen for immigration purposes because you renounced. You've done the relief. You're not a covered expatriate because you've done the relief procedures for former citizens. By the way, there are other conditions that have to be met. So you've solved all your problems. You have a U.S. citizen kid. When that kid grows up, you can leave them, in a state without it being confiscated, to the tune of 40% by the IRS. So, I guess what I'm saying here is there's a lot of stuff going on, okay? And, people need competent counsel for this, okay?
No, absolutely, absolutely. John, for somebody who's not under a time crunch to get a certificate of loss of nationality, is there, and who would have a colorable claim of potentially having relinquished previously, is there anything to be lost for them to attempt a backdated relinquishment? And then if
No,
it doesn't,
not at all, not at all. And I'm happy to help anybody who I believe we can achieve that. I'm so happy to help people do that. And the new DS 4079 is specifically tailored for every relinquishing act. So no, there isn't. Okay, but what is clear is that you're not going to. I don't. Okay. unless the State Department just doesn't have any lawyers left or something, okay? Which I doubt. The one thing there's no shortage of in the world is lawyers, okay? It is very, very clear that it has become much, much harder to persuade the State Department that a CLN should be issued based on a past relinquishing act. And I think the longer they are in the past, the harder it's going to be, okay? But, if somebody wants to dig their heels in, no problem. But I think what they need to understand is that we could be at this for years. I mean, I've helped one or two people, well, more than that, but ones I can think of, overturn a negative decision from the State Department on a backdated relinquishment, okay? But it has, well, one exception I can think of that was very fast, but generally it takes a lot of time, okay?
That's good info.
And
So we know, of course, you made a compelling case that renunciation is a lot more reliable, especially modernly, than attempting a relinquishment. John, just as an intellectual exercise, and with the caveat that everybody's situation is different. They need to get advice about their particular situation, especially given their constraints and their preferences. But would it be possible just to make a list of all potential benefits, however small they may be or niche they may be, to a relinquishment over a renunciation? Could we just do that? Could we go through that and just shout them out, almost like a listicle, right? Just so that people.
yeah, you're probably your style thing is more conducive to that than mine, right? But 'cause I don't like forms, I don't like lists, But in any case, it's just me, right?
Okay, nope.
But I think the Reed Amendment, okay, is the first, and I think that's very, very valuable because a lot of these people in Congress are so crazily punitive, right? And they think only in terms of renunciation. They have no understanding of this at all, right? So I mean, you clearly avoid the ambit of the Reed Amendment. For those people for whom firearms is an issue, you're going to avoid that. It seems to me that the timing, I think, can often be a big, big deal. Because if you're not a U.S. citizen when your kid is born, the kid's not, he's not going to get whatever word you want to use here, citizenship through the parent, derivative citizenship. I don't know. That's an issue. I think the tax thing is an issue, although, that's not guaranteed, okay, because, there's this sort of, the problem is this, right, that what happens is they throw out these laws and then they leave them to lawyers to try to make up how they should be interpreted, right? And as long as you've got a reasonable percentage of lawyers who want to take the position that these laws are retroactive, you can have all kinds of problems. But I think the tax issues are very, very important, okay? I think that the date of the potential relinquishing act is very, very important because if it happened because if it happens between 2004, arguably you're out of it. If it happens between 2004 and 2008, then you're still on the hook until an 8854 is filed. And if it's after June 16th, 2008, okay, then of course, then you need a CLN sort of thing, right? So, the date of the relinquishing act is of critical importance. And I actually think that that's probably the most important one. I don't know, there's some. What do you want to add?
Do you think relinquishing U.S. citizenship as a practical matter might make it less likely for somebody to show up on the expatriation list, irrespective of what
No.
26 USC 6039G
No,
said?
not at all. Not at all. You mean 6039G? No,
Yes.
not at all. So on that thing, there's so much misunderstanding of that out there. What triggers inclusion on the list is whether a CLN is issued by the State Department. That's it. It has nothing to do with whether you're a covered expatriate. Contrary, I know there's a critical mass of people out there who say, it's only covered expatriates on the list. That's not true at all. And whether it's a relinquishment or renunciation doesn't make any difference, because what the statute says is that it's the information is forwarded to Treasury based on the fact of the CLN being issued. Right? The certificate of CLN means certificate of loss of nationality, and that explains the reason for the loss of nationality, right? Anyone can say so-and-so renounced their citizenship. So-and-so can say, became a citizen of, whatever, Canada on such and such a date, et cetera, right? Actually, sorry, here's another one that's very, very interesting, and this is a live case that I've got, I think, going on. Okay. I don't want to, let me tread sort of gently here, as gently as I'm willing to tread. Okay. I don't think that expatriation is all that well understood. Okay. Now, I know that the man who you referenced earlier said something in his tweet that they didn't understand it. I think that's true, but I think that's also, I think that's also generally true, in the legal profession generally, okay? And so what has happened to a few people is that they have had viable claims for having renounced U.S. citizenship, who were told they were still U.S. citizens and entered the tax system, okay? Now, I can think of at least one instance where I was able to get somebody a backdated relinquishment even though they had started to file taxes, okay? Fortunately. But, this really got escalated after 2017, particularly, this whole subpart F issue, transition tax, et cetera. So this one guy who I'm like 99% that I could have gotten him a CLN based on what he did, a long, long time. And by the way, all the facts lined up for him. Okay, I mean we're doing a 30,000-foot overview, but I'm confident that we could have done this. He was told by the expatriation lawyer, okay, that he was definitely a U.S. citizen. And, he then, after having, really been taking the cleaners on the taxes, then went in and renounced U.S. citizenship in present day time, okay? Now, the point here is this, right? And here's what's interesting about this case. There's actually a Board of Appellate Review decision from the early 80s that said that a renunciation was no effect if the person had actually relinquished earlier. You see what I'm saying? So, my theory on this is that, A, he should have tried to get a backdated relinquishment. This was going back, 5, 6, 7 years. He should have done that to begin with. But if he could get a backdated relinquishment today, that would nullify his renunciation period, right? Because you have to be a citizen to renounce. You see what I'm saying?
You think he could get a refund, John?
I don't think that's front and center in his mind. We're talking about a real lot of money here, okay, and tax stuff, okay? But, I offer that in the context of differences between, probably not, actually. No, I'm sure he couldn't get a refund. Are you kidding? But I'm talking about this in the context of, you're asking about relinquishment versus renunciation, right? And, I'll put it real simple. This guy got very bad legal advice.
Oh, absolutely. So, it sounds generally, and I know, obviously everybody's situation, everybody needs to get their individual counsel, but it sounds like if you can make a play for a backdated relinquishment again, and you're not sensitive to the timing on getting the CLN, it sounds like that's the path, or maybe for a lot of people. John, just going back to that.
Well, it really depends. It really depends, okay? Because, I want to emphasize this again, that right now, for certain types of people, if they want to get out of the whole problem from a tax and citizenship point of view, the relief procedure for former citizens is a very good way to do that. And that's available only for a relinquishment after March 18th, 2010. And that's a very strong argument just to bite the bullet and renounce, okay? Most people, I'm interested in this, obviously. You're interested in it, obviously. The people on this call, I don't know how many are here, but they're interested in it, obviously. But most people have no interest in this stuff at all. They just have a problem they need solved. Help, I'm being accused of being a U.S. citizen. What can you do for me? I need to escape, that sort of thing, right? But, if you've got a lot of time and you're willing to settle in for no exaggeration, 4 years and counting with some of the people I know, with no response, then go ahead. But I think that the vast majority of people are going to have a very difficult time putting together a file of facts, evidence, proof to get over the hurdle. That's what I think.
Understood. So going back just to this this expatriation list, right? And I tend to think, the question for most people, the question of who exactly is included is kind of a question of curiosity. Although there are some people, right, that greatly value their privacy and they want to know, right, if they're going to be listed on something like this. Obviously, there's different views on A, what the law says about who's supposed to be included on the list, and then B, in practice, who actually gets included on the list. So just to be clear, John, your position or your understanding is that legal permanent resident expatriates are not mentioned, are not on the list. Is that correct?
No, they are on the list because 877A of the Internal Revenue Code has a section on it that says after a certain date, green card holders are effectively treated as citizens, right? Now they should be. What I would suggest you do if you're in front of a computer, I would invite you to simply open up Internal Revenue Code 6039G.
Yeah, I have it in front of me.
It's not complicated. There's a section that says for citizens, they issue a CLN, it goes to Treasury. And now I think that the green card thing's a little bit different, okay? There may be, and I'm not as up on this as, perhaps I could be, there may be an argument with green card people that it's covered expatriates.
Got it.
But I'd have to look at that again, okay? But for citizens, there's no question, all right, that whether you're a covered expatriate or not is irrelevant, okay? The other thing I would say is that it's common knowledge that there are plenty of people who never appear on it.
You think that's just a mistake?
Well, it's inadvertence. They don't care about this. I'm sure they just regard this as, one more stupid thing. And, and it's really offensive, right? To publish, this doxing thing, right? To publish people's private information online like that. This is, we talk about the content of these laws. This is incredibly offensive.
Still better
that they
than
would do it.
still better than Norway, where they apparently literally have a wall in the tax office to name and shame, allegedly.
Is that right? Huh? Well, yeah, that may be. Maybe it's better than Norway, but no matter what, this is this is a process that's carried out according to law. The people who do this are trying to obey the law. So I really don't see any reason at all why they should be publicly. I think the intent is to shame them. Most people aren't ashamed. Most people are proud of it.
For what it's worth for listeners, I made two Freedom of Information Act requests from Department of State asking for any and all documents and communications containing a tally of the total number of certificates of loss of nationality issued in the year, I asked for fiscal year 2023, fiscal year 2022. I take all responses to Government Freedom of Information Act requests with a grain of salt, okay, because they so commonly come back incomplete, incorrect, etc. But for what it's worth, the number that they responded with for fiscal year 2022 was 4,798 certificates of loss of nationality issued. And the number for fiscal year 2023 was 6,615. And I'll probably in the next month or so do another FOIA request asking for 2024. And I'll probably do one going back as well, going back to 2021. I guess I'll give myself a homework assignment, and I haven't counted up the number of people on the expatriation list from fiscal year 2022, 2023, but I'll probably go and somehow get that tally and just compare it to what the Department of State says was the number of certificates of loss of nationality that they issued. Now, granted, I don't expect, because obviously communication of information takes some time, right? I don't expect it to be, a one-to-one ratio of exactly how many, CLNs were issued in a year, meaning that exactly the number of people that are listed in that expatriation list should match it. But it might be an interesting exercise just to see how those numbers stack up.
Yeah. So Helen Berggraf, who used to write American Expat Finance, had a particular interest in this topic. Not sure why, but she really was into this. And one of the things that that she had reported on is that there are plenty of instances of people appearing twice, and etc. I mean, they obviously do not put a lot of care into putting this list together.
Yeah, and that seemed to be the impression of Brad Banias, the former DOJ lawyer, who he also had a tweet saying basically that his general feeling is that none of the agencies involved in U.S. expatriation, from Department of State to the IRS, really have a good handle on the process, nor are they invested in making it be kind of I guess, an efficient process. Do we have questions? Does anybody have questions? Anybody want to chime in? You can ask questions. John doesn't bite. I don't bite.
I've seen the raw numbers, as true or false as they may be, inaccurate as they may be for a given year for renunciations. But when you actually did like the FOIA request or anywhere, if you dig into it, they don't state whether someone was a covered expatriate or not, do they?
No.
No.
Well, not my request didn't make any distinction based off of being a covered expatriate or not. My exact request as phrased was any and all documents and communications containing a tally of the total number of certificates of loss of nationality issued in the year 2023.
Got it. Thanks.
Yeah, exactly. I want to talk a little bit about returning to the United States as a U.S. citizenship renunciant or a non-renunciant relinquisher, right? We already touched on the Reed Act, which of course is a ground of inadmissibility, right? It means if you're deemed to have, renounced for the purposes of avoiding tax, that you're inadmissible to come to the United States. For the record, inadmissibility in immigration lingo basically has three main consequences. Okay, it means one, you cannot get a visa to come to the United States. Two, you cannot enter the United States. So, for example, in the case where you have a previously existing visa. And then three, it means you're barred from adjusting status from within the United States. Adjustment of status means applying for a green card from within the United States in which you stay in the United States. So that's what a ground of inadmissibility is. We talked about the Reed Amendment, but there's also obviously the other concern, which is probably a bigger concern, given that there's so few instances that we know of somebody being barred from the U.S. based on the Reed Amendment, and that's just the fact that you give up your right to be able to enter the United States when you are U.S. or when you renounce or even relinquish U.S. citizenship, right? John's talked about this. John has a great presentation among his many, obviously, on the IRS Medic podcast from, I think it was about a year ago. It was like, returning to something about returning to the United States as a renunciant. I've, of course, written a little bit about it as well, too. Getting a visa is the biggest concern, right? If a person renounces or relinquishes U.S. citizenship, right, they have to, if they want to return to the United States, return as a citizen of another country, right? And that means one of a few things. Okay, if you are a citizen of a country that's on the ESTA, in the ESTA program, right, then you can enter the United States, applying for electronic permission. If you're a citizen of Canada, right, no visa is required, no ESTA is required. But if you're not a citizen of a country that has visa-free access to the United States via ESTA or otherwise, you have to apply for a visa to come to the United States, right? And that, it's far from a guarantee, right? That when people apply for U.S. For a U.S. visa, that they'll be able to return, even if they're a former U.S. citizen, perhaps especially if they're a former U.S. citizen. I don't know what the numbers are. We have a few, just anecdotally, there's a few, high profile U.S. Renunciation cases. I'd argue maybe Edward Saverin might be the most, I think he's probably the most famous renunciate. What do you think, John? Is there a more famous renunciate than one of the Facebook founders, Eduardo Saverin?
Tina Turner?
Oh, yeah, that's a good point. Tina Turner as well.
I don't, probably, anyway, okay, there's sort of an elite club, right? To say, ripping off the U.S. or something. But, Savin would be in there. Tina Turner probably would be in there. Roger Vere's, in the news lately. He will be there, okay, as his case, becomes more well-known and that. I don't know.
Yeah, and there's also in this space, there's Andrew Henderson of Nomad Capitalist. He's kind of I guess a consultant type, I guess you'd call him. He puts out a lot of content. I think most people, he's pretty well known in the industry, and he's a famous renunciate. And somebody sent me his video from 4 or 5 weeks ago, I think, where he basically says that after he renounced, he applied for a visa shortly thereafter. I think it was only a year or two afterwards, tourist visa to be able to come to the United States to visit his family, and he was denied. He talks about in there, right? Now, I would caution anybody from using that as evidence that if they renounce, that they're not going to be able to come back. That's just one. It's a sample size of one, and he's also highly famous, or not famous, but highly well known, basically, as like a guy who has renounced U.S. citizenship, right? But it's a concern for sure, right? I've said, at least from my perspective, being a citizenship and immigration lawyer, I don't do tax, but from my perspective, among the people that I speak to that are renunciation curious, their biggest concern is trying to get a handle on how likely it is that they're going to be able to return to the United States as a visitor or not. Do you think, John, that's also, generally speaking, the main concern of people who are renunciation curious? Is it the number one concern?
Yeah, I think it is, but it's so much of this is habitual thinking, right? A lot of the people who I have worked with have renounced U.S. citizenship. It's some are concerned that others aren't at all. The United States, for it's a concern, and the problem is that the whole U.S. system is, generally, the U.S. is a country that is fundamentally based on the principle of certain penalty for uncertain conduct, right? In other words, the consequence is out there, this bad thing will happen, but you're never really sure for what, right? I think that this is a concern, but I have not found that it's a big enough concern to dissuade people. I think they sort of factor it in.
It's a big enough concern
now,
for me.
That statement of mine, Sorry, it's a
I was gonna
concern?
say that is not that I don't even really have an interest anymore, but when I was seriously considering it, that was absolutely the stopping point. I mean, I think it's a totally personal thing, right? But
It is a personal thing. And of course, then the question is, I mean, so um, you renounce, you're not a U.S. citizen. I mean, I think we all agree. Frankly, I'm not even sure that a U.S. citizen does have a right to enter the U.S., but let's presume that to be the case. But clearly, people who are not U.S. citizens do not have a right. Okay. So, they're evaluated, based on what country they're a citizen of. And of course, as Parviz will tell us, I think it's 214 of the Immigration Nationality Act, I think says that if you're not, that to enter the United States, basically you have to prove that you're not intending to stay permanently, right?
That's absolutely right. Presumption
That's,
of immigrant
that's a
intent.
paraphrase.
Exactly.
Yeah, but I mean, that's the governing principle. And that, by the way, I'd be interested in your comment on this. Every time I fly into the U.S., I'm just horrified, with the whole lineups and customs and everything. And, I think that's probably just the result of Section 214, isn't it?
I'd say historically, yes. Now a lot of people are scared of their electronic devices being seized. It's not a new.
Yeah, that's it. Yeah, yeah. I mean, it's not pleasant to enter the
No,
United States.
no.
It really isn't. There's no point. No, whether you're a citizen or not, it's not pleasant. Okay. But the point is that the question of whether you will be allowed in is, at least in the first instance, a question of what's your citizenship, right? So if you're a Canadian citizen, and this is why Canadians who renounce are giving up far less than citizens of other countries, you can kind of waltz in with a Canadian passport, right? Assuming that you don't have a criminal record. And I have had a few people over the years who I've suggested to not renounce, because, I thought at the very least that could become a subject of discussion, right? So for somebody who's a citizen of, with sort of a weaker mobility passport, I don't know, would Pakistan qualify as that?
Definitely.
sure.
Yeah. Okay. So, I think that somebody like that, I mean, I would suggest that I would not advise them to renounce U.S. citizenship. I mean, unless they want to run the risk of, I mean, it's not a visa waiver country. It's not Canada. It's not Bermuda. You know, um, I think that they would have heightened concerns.
Do you think that that's even maybe more true as, at least in my opinion, the momentum of just this populist air of the current era exists? Because it feels like whenever you have populism, even if laws are written down and whatever, they're less certain than in, let's say, more sane times. That's just my opinion, but I'm curious your thoughts.
So let me just add to what you said. Okay, the laws are just the beginning of the inquiry. The interpretation and application is a very different issue. Okay. So, I mean, you can easily have, I mean, this is true everywhere, right? Particularly a country like the United States that is so long, with regulations and, this sort of stuff. Now, I am, I am appalled at what's going on in the United States right now. I mean, I'm not taking a position on whether these people should be deported or not. I don't know anything about them, but I do. I'm not some leftist guy at all, okay? But I believe that people have procedural rights, okay? And I don't think people should be rounded up and, this sort of stuff. I mean, I find this stuff appalling, right? But for whatever reason, there are people who object to it, but I don't sense strong objection to this in the United States. I mean, there are people, but there's a lot who for whatever reason, don't see anything wrong with this, right? And now this is having an effect, okay? I don't know. I think that the media, for example, in Canada probably exaggerates a little bit. But there's no doubt in my mind that people in Canada are interested in and this is very, very bad for the United States. There's all these small businesses, that are dependent on this stuff. And this whole brouhaha over students, I mean, this is just my opinion, obviously, and I emphasize it's my opinion. But, I think it is in the interest of the United States to have foreign students coming to the United States to study without fear. I mean, first of all, you can indoctrinate them into American values, so to speak. But secondly, these people create huge local economic spin-offs, right? For communities where these colleges, universities are housed, whatever, right? I mean, imagine how much of the Massachusetts economy is tied into education, student spending and stuff, right? So, I don't know. I mean, I just don't think this is being well handled, and I think that the long-term impact of this is going to be very, very bad. Because I don't think that, I think that a certain percentage of people are going to be looking elsewhere and, not go to the United States or whatever. I don't know. Do you agree with my thoughts on this or disagree? Or
I don't disagree, at least for a time. I mean, it is really interesting. I went back and looked at what I would argue are the three other major populist eras in U.S. history, which I would define as essentially Andrew Jackson, Teddy Roosevelt, and then FDR. And it is pretty interesting. A lot of it rhymes, in particular with immigration, looking for someone to blame for whatever issues are there. And obviously immigrants are always easy to pick on. But I even looked up the immigration figures and, kind of similar to what we're seeing now, like there was huge swings. So I agree that it is damaging, but I'm not sure if it's comforting or worrying that this doesn't seem like the first go round that we've been through. And obviously, I mean, just speaking of the United States, pick any other well-documented, at least a developed nation, Western European nation, etc., and you tend to see similar trends.
do you read Professor Heather Richardson's Substack?
I have not heard of Professor Richardson, but maybe if
You're
someone
kidding
could
me.
share the Substack, I'd like to.
Oh, it's no relation, by the way, at all. Okay, but it really incredible. It's called Letters from an American. Just look up Heather Richardson Substack. Anyway, the reason that she came to mind is I enjoy reading her. I don't agree with all of it, but it's very, very rich. Okay, and how she talks about different periods of U.S. history. And the reason I mention it is because she was doing a podcast with what's the guy's name? Professor Scott or somebody. Anyway, she was doing a podcast where she was asked if she thought that what was going on in the United States could be compared to what was going on in Europe in the 30s, for example. On her interview, she said, "Well, I'll say this, okay, that she listed a period in American history." Anyway, definitely that. It's she has a real gift. She's a history professor, Boston College. She has a tremendous gift for being able to she'll write it's such say November 5th 2024, and she'll say, well, on November 5th such and such a date in the United such and such happened, right? And then she'll explain that, and then explain why it might be relevant today. It's really amazing. So shout out to her Substack, and she has a YouTube channel as well.
Sounds interesting.
I
Oh,
want
it's
to circle
very
back
interesting.
real. Thank you, John. I want to circle back to 214B. Okay, so that's the presumption of immigrant intent, and I think it's important for somebody who's going to give up access to the United States, whether by relinquishment of U.S. citizenship or otherwise, and depend upon the ability to apply for a visa and enter the United States on that visa in the future, in order to be able to come back to the United States. 214. Imagine CBP officers, consular officials that are interviewing people for visas. When somebody presents themselves, they have different buttons that they can press, okay, to deny somebody. Okay, so they can deny somebody under different sections of the Immigration and Nationality Act, right, for different reasons. Okay, some reasons require more of an internal justification. Okay, for more of a call for some sort of evidence for the denial than others. Okay, and for 214B, okay, so INA 214B basically says that a person that's applying to enter the United States or to get a visa to come to the United States is presumed to have immigrant intent until proven otherwise. So it puts the burden squarely on the applicant to show that they are a non-immigrant. They have non-immigrant intent. It means they want to come for a limited period of time, even if it's a few years, but eventually they want to leave. So what's relevant to a determination of whether somebody has immigrant intent or non-immigrant intent? What's relevant in a person's life to determining whether they want to actually move to a foreign country and stay there or not? Well, I would
Well,
argue that,
their roots in the country where where they're living, right?
what's that?
Well, how rooted they are in the country where they're living, right?
Yeah, that's one of them. That's a huge one. Okay, but I where I'm going with this, John, is I would argue that you can kind of make a claim that darn near any factor in a person's life. Okay, you could make a claim as a consular officer if you were tasked with proving this, and they're not really that tasked with it. And I'll talk about the doctrine of consular non-reviewability in a moment. But you could make the claim that their family situation, who they're married to, what their job is, how much property they have, what they do for a living, their goals, their aspirations, their education. It's not that hard to make a claim that any factor in a person's life bears upon whether they can be whether you can think that they have a an intent to move to the United States to be an immigrant or not, right? So therefore, it's easier. It's easy to deny somebody, okay, for having immigrant intent, okay. Now, when you combine that, unlike, for example, denying somebody for making a previous material misrepresentation, right? Okay, if a consular officer is denying a visa saying that they made a previous, material misrepresentation. Well, they're supposed to document what it is that they're saying is the actual material misrepresentation, right? And that a denial like that is kind of one of the few denials that an applicant might have a possibility of challenging via a procedure that's through something called not Nelnet, LegalNet, excuse me. Okay, where basically, if you think that a mistake was made on a point of law, okay, at the consulate, then you can basically, go through this kind of liaison and have the consular, review it. But generally, visa denials are generally speaking not reviewable. Okay, that means if you're denied, especially if you're denied for something like immigrant intent, okay, you don't have much recourse. Okay, you got very little to no recourse. Now, the doctrine is called doctrine of consular non-reviewability. That's a generality. As with all things legal, there are a few exceptions, right? And there are some small narrow exceptions here, right? But generally speaking, the bottom line is it's easy for a consular official to deny a person, renunciant or not, a U.S. visa for having immigrant intent. They're not tasked with proving something, big or really much at all, other than just, I saw the person, the way they looked, they didn't look credible to me when they said they wanted to come back. And by the way, physical appearance, their behavior, how they answer questions, that's all fair game, okay, for determining credibility, right? So that's, I think we gave short shrift to what John mentioned. John, I think you're absolutely right. INA 214B is really, for people who know a little bit about U.S. immigration law, that is kind of the sword that hangs over the head of any buddy who's relying.
Yeah, that's the sort organically. Yeah, I think there's absolutely no question about that, and I think people don't realize that because there's just so much out there, right? That it becomes hard to know where to focus. And so when you think about a system of law or something, I mean, I find it always helpful to begin with what is the basic principle, right, and try to work down from there, right? But I mean, look, generally speaking, okay, I don't want to, I think it'd be damaging to leave the impression that, people who renounce are going to have difficulty entering the United States. That has not been my experience, okay? Now, could that change? Well, anything can change, right? I mean, all countries have control over their borders, sort of thing. But I think that what we're really speaking to is the problem of so much uncertainty, right? You deal with taxation, you deal with immigration, and it's like I said earlier, the negative consequences are clear. How to avoid the negative consequences is not very clear, right? And that's why there's so much anxiety over this. I mean, it's a really, really bad situation. Coincidentally, I started my day very early. Well, you will know this because you saw my tweet, right? Talking with this guy, it wasn't even a legal consultation. He just wanted to talk about the renunciation decision, right? Well, maybe to some extent it was, but I mean, and he was just sort of tormented. I mean, he feels he's being, forced out of U.S. citizenship, right? But so much of this, revolved around what happens if I renounce, and how can I be certain of the consequence here or there? I mean, it was the same kind of thing, and that's why I thought I'd try to put together a list of how to think about this. And the only answer that I can really come up with, people, is that we start from the principle that U.S. citizenship is a huge problem for people who don't live in the United States. So the question is, do you want to go through your life with these problems or not? I mean, unfortunately, options in life, especially the older you get way too expensive. And, for somebody 50 plus, I think the option of remaining a U.S. citizen if they're a tax resident of another country is far too expensive. For somebody who's like 20, no problem.
Unless I'm remembering correctly, I don't think it was actually, I know it wasn't passed, but it may have been a part of the Reid Amendment that didn't become what we know the Reid Amendment to be now. Wasn't there actually a suggestion that I want to say it was one of the Democratic senators, but again, don't hold me to that, that they tried to say that if you are believed to have renounced, I want to say it was period. It wasn't for tax purposes, but it was period, that there was a suggestion or desire to disallow people from being able to apply or come back, period, for a visa.
Was that
Could be
Casey and Schumer? That was around 2000.
Yeah, I think it was Schumer. That's what I thought it was. I thought it was Schumer.
Let me just see what I can find on that. So let's
The only reason I bring that up,
Casey,
the only reason I bring that,
Schumer, renunciation of citizenship. Let's see what we can find. Yeah, sorry, go ahead.
the only reason I bring that up is because, I mean, obviously what we're talking about now is the state of affairs. And as you said, laws can change. But that alone, like, I know when I read that and back in a period of life where I was really considering this, man, that scares you straight, at least in the sense of, to even have uttered that to the point where we can go look up a quote, that is more than a suggestion in a back room. And again, I think if you go back to populism, it's like, all it takes is the right, some high profile whatever, because that's usually when these things change, and they pull that back out and add it on top. I'm not trying to fearmonger at all, but
well, okay.
Yeah.
So I just put into Google the following: Casey Schumer, SCHUMER, renunciation of citizenship. Whole pile of stuff showed up, okay, on this. And this is in 2012. Even in tax notes, Schumer Casey announced bill to prevent renouncing. Casey, Edward Saverin should pay. Look, these people are absolute morons, okay? They're absolute morons. They have
I
no
think it's actually
idea.
pronounced psychopath, but yeah.
They have no idea what's going on. I mean, did they not understand that Saverin would have paid a huge exit tax? Do they not understand that Tina Turner would have, of course they won't go after her because, they like the music, but
Yeah.
John, I'm not sure if other people have a hard time hearing you, but I can't hear you at all for the last 10 seconds or so.
Yeah, I
Same
couldn't
here.
hear him either.
You there, John? Okay, John might be having some connectivity issues
Throw
there.
another question. Can I throw another question out there?
Go ahead.
So you were talking about the various things that makes one inadmissible for applying for a visa, and I believe that covers ESTA too, because don't they ask you, are you disqualified any? I don't remember. I could be wrong with ESTA, but in terms of just what makes one inadmissible, the reason I bring this up, I was reading about a non-immigration case yesterday where someone was a green card holder of the United States, had been living in the United States for 20 years, had never naturalized, but had been convicted of a felony, a drug-related charge, served 90 days, so nothing huge, but then left the country. And while they left, their green card expired, came back in. Obviously, you can't get back in on a green card. And he was arrested or held, whatever you want, detained for trying to enter on an expired green card. And was held for 3 months and then got someone to argue his case that he should, even though he was disqualified based on inadmissibility for being a felon, that it had been long enough, there was a cooling off period, that they should be allowed. And then a number of, I believe it was 5 years later, they actually did eventually naturalize again, even though they had this felony. In regards to either being inadmissible based on the Reed Amendment or any other thing that can make one inadmissible for immigration purposes, let's say related to either relinquishing or renouncing citizenship, I haven't read that there's any sort of cooling off period or a look back period like that. Am I correct in saying that?
I'm not sure what you mean by a cooling off period.
Like they had
So,
said that since the conviction was 15 years ago, and they, the person had since then demonstrated good character, blah blah blah,
mhm.
that they were not technically inadmissible since enough time had passed since their felony conviction.
That description sounds like something's missing that from the story. What you're describing to me sounds like possibly being put into removal proceedings and winning on a type of remedy that's called cancellation of removal. Right? Cancellation of removal is available to either green card holders or non-green card holders who have been present in the United States for a certain period of time, can show ties, and compelling reasons, like to be able to have the removal proceedings canceled. Green card holders typically are not arriving immigrants when they come to the United States, unless like one of us, unless there's some criteria that makes them so, like having been outside the United States for longer than 6 months. So I'm not sure. I couldn't tell you. There's no look back period, at least not described as such. I'm not sure exactly what happened there. The thing I would say for people that are renunciation curious or not, to know about inadmissibility, okay, is that, like I said, it typically means three things. Okay, if you're inadmissible, can't enter the U.S., can't get a visa to come to the United States, cannot adjust status from within the United States. Okay, unless, okay, and maybe I should have mentioned this at the beginning. unless you get a waiver of inadmissibility. Okay, there's certain waivers available, and I don't want to go too far down that path because it gets extremely complicated very fast. Or unless it's a ground of inadmissibility that can be just remedied by the passage of time or change in circumstance. Okay, perfect example is immigrant intent, right? Somebody could be denied on immigrant intent, okay, and they could go off and basically for 5 or 10 years have develop more ties with their country, apply again for a visa, and then they're no longer deemed to have immigrant intent, right? So there's certain grounds of inadmissibility, health grounds of inadmissibility, okay, can be remedied sometimes without a waiver, okay? How? A person has a disease, a certain infectious disease, and they're cured. They no longer have the disease, okay? So they're no longer subject to that ground of inadmissibility. For renunciants, or relinquishers, John was dead on the money. Okay, the same thing that matters the most for everybody else matters also for them, which is making sure that you can prove non-immigrant intent to come to the United States. And I have an article actually that I published about 1.5 years ago. It's called U.S. Citizenship Renunciation with Maximum Access to the United States. And this is just a thought experiment in this article where I go through what I would consider the ideal profile of a U.S. citizenship renunciant that would be able to return to the United States, that would be able to maximize their chances of returning to the United States. The ideal profile doesn't mean it's a guarantee. There's no guarantee. I just basically list the qualities that I think this person would have in order to have maximum ability to or chances to re-access the United States. But inverted, if you're welcome, if you find out more what you're talking about in that issue, you're welcome to bring this up in a future space if you like. And if you have more details, I'd be happy to give my take.
Yeah, I appreciate it. Thanks. I was more. I mean, I appreciate everything you're saying, but I was more curious if there was any sort of cooling. I realize that's not the term. Cooling off period, look back period, whatever, for specific relinquishment renunciant. But your answer makes perfect sense.
No, as far as inadmissibility is concerned, I'm not concerned. So remember, relinquishers of U.S. citizenship are subject to any of the grounds of inadmissibility that anybody else would be subject to in order to try to come to the United States.
Right.
If you lie on an application, you could be hit with material misrep, okay, which means you're inadmissible. Obviously, immigrant intent. In addition, of course, renunciants have, at least in theory, right, the added risk of being considered inadmissible under the Reed Amendment. Although, and I guess, John, I think it's probably time for an update inquiry on whether anybody's been, in the last few years denied a visa or access based off of the Reed Amendment. The last I checked, there was that congressional hearing where a Department of State official basically reported that from, I believe, 2005 to 2015, the Department of State only had a record of 2 people who had been either denied or attempted to be denied per the Reed Amendment. I haven't really looked into it much, in the last couple of years, but obviously that would be very interesting and possibly illuminating. But
of those 2, I think one of them actually successfully challenged it as well.
Right.
If we're talking about the same guys,
I think you're right. I don't remember precisely, but I remember. I think one of them got in even eventually. There's no implementing regulations currently.
Can you hear me?
Last I checked. Now we can. Go ahead.
Can
John.
you hear me?
Yeah.
Yeah, I just wanted to add on that.
John, I can't hear you anymore. I don't know if others can. Inverted, can you hear John?
No, he's breaking up for me as well.
Okay. All
John,
right, that's interesting.
We're only hearing about 1 out of every 5-6 words.
Okay, you know what? Why don't should I leave and log back on?
Yeah, try it. Why not?
Okay, I'll leave and come back on. All right.
Bang on the side of the phone like we used to do with TVs.
Have you guys discussed children and renunciation yet?
Not that much. Very little. John touched on it a little bit, basically. We touched. Yeah, not that much. But go ahead if you have a comment or a question or whatever you'd like to say.
You're both on the topic of children and U.S. citizenship. So there seems to kind of be this increasing idea that U.S. citizenship is a curse and those considering birth tourism should no way do it in the US. I'm wondering what people's thoughts are on that and what the counter argument is. Because my initial thought would be, well, if the kid can renounce, especially below 18, then it might not actually be that much of a downside, and better to give them the option as opposed to them really wish they could have been American.
So, John, the question I believe is if you can come to the United States, have your kid born here, they're born a dual citizen, right, and they'd be able to renounce. Does it still make sense for the potential upside because they can get out by renouncing?
Does it make sense for the kid to be born in the U.S.?
Does the possible strategy make sense to give your kid the option of being of living their life as a U.S. citizen by doing birth tourism to the United States, if the kid would also be born a citizen of another country, so dual citizen from birth?
Yeah, sure. Well, I mean, I think so. I do not believe these laws are so insane. I don't think they can go on forever. But I do think that I think that there's a certain amount of education that's required before people do this stuff, because citizenship has huge consequences, and it'd be interesting to see if the Trump administration gets some kind of a judicial seal of good housekeeping on the idea that people who are born in the United States to people without status are citizens, right? So, sure. I don't see why not. Look, I think U.S. citizenship has value. I think that it just comes with a hell of a lot of problems.
And you talked that things may change. Do you anticipate any changes happening for renunciation or relinquishment in the coming years?
Well, I think that the whole thing has to change. The whole idea of what citizenship is and taxation. But it's clearly not going to happen overnight. It's going to take some time, and I read something on the weekend that was unrelated to this, but really convinced me that we are a long way from anybody taking these types of considerations seriously. Look, my thinking is people who are 50 plus who are tied into other countries, citizens of other countries, probably should consider renunciation, okay? And sooner than later. Now, here's why sooner. Here's another dimension of this that I don't think we've discussed. Is that if you look at 877A, right, that's the statute that creates these problems, exit tax and stuff. The statute actually requires Treasury to make regulations governing this. They've never made regulations. And I assure you that the next step in tightening this is going to be Treasury regulations on this stuff. And I think I would encourage people to get out before that happens, because I could see them imposing all kinds of, craziness on this that would make it even more difficult. And another group that has got to get out are U.S. citizens abroad with U.S. citizen children, where the parents are not dual citizens from birth, and just through inflation, they're going to clear the 2 million thing. They've got to get out as fast as possible to preserve their ability, if their kids remain U.S. citizens, to leave them their estate without, losing 40% of it to the IRS. So long run prognosis good, short run not good. What does short run not good mean? I'm sort of at the 50 plus. I think 50 plus, I think you should get out. And I think that people need to understand that renunciation of citizenship is an important part of estate planning. Because, there's all this discussion about compliance versus non-compliance. And I have seen, particularly in the last few years, maybe I'm just paying more attention to it, people dying and the state executors and administrators getting into the question of whether they're U.S. tax compliant, right? And believe me, nothing good can come from that. Okay, you know, it means all kinds of expense, hassle, etc. I think people should bite the bullet. I really don't think they have a great deal of choice here. Okay.
All right. Go ahead if you had a follow-up question.
May I ask a question? Yeah, I wanted to ask about the exception to covered expatriate status for dual citizens at birth. As I'm sure you know, a lot of countries have a distinction between nationality and citizenship. And I'm wondering if a person who was born as a U.S. citizen and as a national of another country that doesn't immediately grant citizenship, maybe they delay it until age, 18 or some later time. Does that person qualify for the dual citizenship at birth exception? Does the IRC recognize that kind of nationality as another citizenship?
First of all, there are requirements other than the citizenship at birth, just to be clear, to use that.
Right.
However, to answer your specific question, I don't know. That whole area is, it seems to me to be mostly ignored by the accounting and legal professions. But what I think on it is this, that as far as I can tell, should this become an issue, the U.S. would defer to the law of the other country on the issue of citizenship. And so you go from there. I think that the key distinction on it is likely to be the status at birth, though. Because remember that any status that is conferred after birth is, you're kicked out of the dual citizenship, that particular exemption, right? So I don't know.
Right. Okay.
Yeah, it's a great question. And then there's this category of thing, right, that some countries have that I call, and I wrote an article a long time ago, I call these semi-citizenships, and it's just my attempt to try to coin some sort of term, that describes these things. And these are oftentimes expressions of nationality by a country, but without full citizenship, meaning typically without the ability to vote or have a passport. Sometimes they're, for example, Lithuania has a certificate of Lithuanian descent, okay, which they kind of internally refer to as a nationality, right? It's kind of these concepts, these statuses that are trying to impose or establish some sort of relationship with the person in the country, but is less than full citizenship, right? There's Slovakia has something called a Slovak living abroad, okay, and they basically refer to those people as parts of of the Slovak nation, Slovak nationals but non-citizens, and I would guess, I mean, to David's point, maybe it's going to take somebody who has one of these things from birth, right, to try it out, right, to try to renounce and claim the exemption and see where it goes. I have no idea if somebody's tried this before, if there's any case law on it or not, but that's what came to my mind. I'm not even sure if that's exactly what David was referring to, but that is what came to my mind automatically, this category of what I call semi-citizenships, which very often reference nationality without citizenship in a foreign country.
Well, I think that the issue is so they clearly look to the other country to determine what the status was, and I suppose, yeah, I mean, I think the governing issue there is going to be, first of all, whatever the status was at the time of birth, does it give rights that are analogous to a right of citizenship? I think that's the issue, and that's how it should be analyzed. I would make the point, sort of parenthetically here, that this is dealer's choice, right? you file the 8854, you're the one who checks off the boxes. Now, obviously, we always in life, when we fill out forms, are truthful in our forms, right? But, if somebody believes that they have a case for this, then I think probably, go for it. As long as they understand the risk of somehow not being successful. See, don't forget that particular issue, the dual citizenship from birth exemption, has nothing to do with renunciation. It has to do with covered expatriate status, right? So, you renounce, you file an 8854. Maybe you're not a covered expatriate anyway, right? Net worth less than 2 million, you're compliant on your taxes, etc. Maybe it doesn't matter because you're not a covered expatriate anyway. But you put it as, well, they asked the question, shall I put it? So in a case like that, they, what difference does it make if they challenge it? It doesn't, because you're not a covered expatriate under the conventional rules. But this is a gigantic problem, and people have got to be very, very careful. Let me give you a very common example that, or at least common in my world, that I've seen a lot of, right? So we have somebody born in the United States to a Canadian citizen parent would be a Canadian citizen from birth. We have somebody born in the United States to an Australian citizen parent. No, they get their Australian citizen after birth through sort of a fast-track naturalization. So, again, it's funny because I think the conventional wisdom in the retail world, meaning people on these Facebook groups, they have no clue, what the level of the number of moving parts, the complexity that can be involved in this.
For a CRBA, someone born abroad, do they get their citizenship when they're born,
Yes.
even if no CRBA is filed?
You're talking about a certificate of birth abroad. That's just a recognition of U.S. citizen. It doesn't make you a U.S. citizen.
But don't you have to prove the residency requirements were met?
Well, you're talking about two completely different things here. Okay, you're talking about, there's the dual citizenship from birth issue. And then if you're a dual citizen from birth, to use that exception in 877A, then you've got some residency requirements, which my memory is something you can't have lived in the United States for more than 10 out of the previous 15 years, or more precisely, haven't met the substantial presence requirements under the Internal Revenue Code. But, these are completely unrelated issues. Yes, of course.
I changed the topic.
Of course, you have to meet the residency requirement, but that's to use 877A. You have to be a dual citizen from birth to use 877A. But, whether you're a dual citizen, whether you're a U.S. citizen from the point of birth is an issue that's independent from using 877A, right?
Yeah, I was just thinking, for people giving birth abroad, would their kids have to be compliant with all of the U.S. citizen reporting requirements? If a CRBA was not filed, would the kids still be a U.S. citizen if the consulate had not confirmed that citizenship was transferred?
Yeah. I think, I don't see any issue there at all. Why do people get, these types of, confirmations of birth abroad? Well, because they want to prove they're a U.S. citizen. But these things are issued because they're U.S. citizens. They don't make them U.S. citizens. The issue of that doesn't make you a citizen. That's like saying that, the issuance of a passport makes you a U.S. citizen.
Which a lot of people believe, by the way. I would venture to say maybe a majority of the people. Alex, I think the answer to your question is the proof of a fact and the actual existence of the fact are two different things, right? Especially in the legal world, right? So even when there's residency requirements, right, of the parents in order to prove the citizenship of the child, the residency requirement, the residency of that person, of the parents, existed regardless of whether a CRBA is requested or never requested. It all exists out there. I mean, imagine we start in a world where there's no forms, there's no, CRBA at all, right? You'd have a hard time proving it, okay? Proving, right, that this thing happened by operation of law, that the person acquired U.S. citizenship at birth, but it would have happened, even though there's no proof of it yet, right? People apply for and get the proof, okay, to be able to, enjoy the benefits, right, of whatever it is. But conceptually, I think it's important to make a distinction between the two, right? And that's kind of what John, and you weren't here at the beginning, Alex, of the space. John and I kind of were talking about how this issue is so important and it's kind of makes people's eyes glaze over. I'm not saying it would make your eyes glaze over, Alex, but this issue of, proof of something versus the thing, right? And oftentimes, because a legal fact, something that happens by operation of law, is so intangible that sometimes people have a hard time imagining that thing can exist without the paper to prove it. But that is actually the way it works. Okay, the thing, the legal fact occurred, it exists, and then you get papers after the fact to prove it, to prove that it happened.
So, following up on that, for some non-married fathers, for example, if the father is the American citizen, to pass on citizenship, they must agree to support the child till they're an adult. And there's a form in which they can agree that they support the child and will continue to do so until they're an adult. But you're saying basically in theory, they don't necessarily have to sign that form if they either are already required to support the child by, say, a court order or some other means, then the kid could apply for citizenship. It just might be a more roundabout process. Maybe they have to sue to go through the non-traditional process.
Yeah, that's pretty much right. And in fact, if you look at some of the case law, like cases of, for example, there's some case law specifically on U.S. citizen fathers who give birth to a child in Mexico. Okay, and I don't have it in front of me right now, but U.S. law regarding acquisition of citizenship when the father's a U.S. citizen and the mother is not, has as one of the requirements basically claiming paternity. Okay, I don't have it exactly in front of me, but basically claiming paternity. And like you said, you made reference to it, either support of the child or promise to support the child until the age of 18. Okay, now paternity, what's considered a claim of paternity? Okay, U.S. law references and incorporates foreign law, okay? Because the US law says basically that we look to the law of where the kid is, okay? And if under that domestic law, in this case, we're talking about Mexico, the actions
Where they are or where they're born?
where they're, I don't remember off the top of my head, born versus are. I'm not sure. I want to say R, but anyway, it's one of the two. But the point is, it incorporates Mexican law. Okay, and then for example, in Mexico, like doing certain types of things, right, towards the kid, if the father does certain things, that's considered to be basically claiming paternity, right? So yeah, I mean, just conceptually, and I don't know if this is even still your question anymore. The things happen, and then you're proving it after the fact, right? By gathering the evidence and requesting the CRBA.
I'm just thinking about sperm donors. So there's the U.S. has some of the most commercial reproductive markets in the world. You can buy and sell sperm, eggs, and embryos. So conceivably, there could be a scenario in which many of those kids end up becoming U.S. citizens if the foreign country recognizes the paternity of the father.
I'd have to have the statutes in front of me to be able to really go through this line by line to give an opinion. So I'll have to withhold opinion on that. But Yeah, I don't know. Maybe that's an interesting thing to. It's not my area, right? It's but for maybe somebody out there is interested to do the work and figuring out whether that would give a colorable claim en masse. Okay, so we're at 121. We've been going for about 2 hours and 20 minutes. I want to thank everybody for their time here. I want to thank John. If there's any last topics that somebody wants to discuss or any questions, please speak up. Otherwise, I'll just make my pitch for the next mobility space. And of course, thank John for co-hosting this and sharing so much of his wisdom. So any last points that you want to bring up, John, that you wanted to talk about? We didn't get to hit everything from your outline, but we hit, I think, most of them.
No, I don't think so. I don't even remember totally everything I say. We certainly had a wide-ranging discussion today. I mean, I think what I would say in conclusion is that, particularly the last few minutes, talking about foreign law and stuff like that, is that you're dealing with, shifting goalposts on citizenship, nationality laws, and tax laws. We didn't even mention the impact of tax treaties, on some aspects of renunciation planning, etc. What I would say is that, people need competent advisors. This is a complex area. It's also a new area, right? Where there's not, a whole pile of case law and stuff, which I think, I don't know if you would agree with this, I think makes the advisor even more important, right?
I'm not sure if it makes the advisory more important, but it certainly puts more emphasis on kind of the philosophical underpinnings of the advisor, right? If they're, in my opinion, if they're working off of less case law. But in any case, no doubt, it's super important. Can somebody be a competent advisor in this without reading primary source materials, John?
Yeah, well, I mean, 99% of what's out there is not based on primary source materials.
You don't say. Okay. No, those are wise words from John Richardson. John Richardson, of course, of Citizenship Solutions, one of the world's premier experts, if not the premier expert on U.S. renunciation and relinquishment of citizenship and the possible tax consequences. So if anybody did this and hasn't heard John, which is probably unlikely, but if you have and you want to hear more or read more, check John out at his website, Citizenship Solutions, as well as his podcast. And he's also a super contributor to the IRS Medic podcast. So this is our 19th mobility space. We're doing 50 mobility spaces this year on dual citizenship, freedom of movement, sovereignty, real issues, real topics. Try to cut out as much marketing fluff as possible. Does anybody have a suggestion for the next mobility spaces topic? Okay, we do these Mondays and Thursdays. If anybody has a suggestion, please say it now. I'll consider it. Otherwise, I will just depend entirely on a poll that I put up. I pick 4 topics I think are super interesting, and I put them up on the poll, and I let the followers decide. So, David, Alex, John, we got Chris here, we got Eloise. Does anybody have a suggestion for the next topic?
Have you done one on birth tourism yet?
No, not yet. I definitely want to do one on birth tourism. I don't really have the appetite to have it be the next one yet, but we're definitely going to do that as one of the 50 this year. Mr. John Richardson, Mr. David Bindell, any suggestion on the next topic? Otherwise, I'll leave it to the poll.
Oh, I'd leave it to the poll.
Leave it to the polls. Okay, that's what we'll do. So thanks everybody for joining, including our anonymous listeners. We have a lot of anonymous listeners. A majority actually are anonymous. So whoever's out there, thank you for joining, and we appreciate it. Shout out to everybody who contributed today, especially, of course, the great John Richardson. And we will put up a poll. I'm going to suggest 4 topics for our next mobility space. The next space will be Thursday, at 11 a.m. Pacific Standard Time. So same starting time, but we'll be on Thursday. Thank you, everybody. Have a great one.